and old route, which is a more gradual route that takes the contours of the hill, whereas the more recent one is made with more of the steps. So the gradient is a lot steeper.
Yes.
So recently, with the very heavy rainfall that we had last season, one of those routes were completely destroyed.
Yeah, we got to see all those clippings and the social media, the number of groups. We could see that it was really very, very furious the way nature's fury we could see. And in fact, that's what prompted us to be more cautious, more careful when trying to ensure development in areas where the nature is still in its pristine form. We have to be careful.
They have responded very well, and both routes are now back to use.
Sir, I had the opportunity to visit the upper reaches of this Jammu to Srinagar highway, National Highway number 1, because it is strategically very, very important. And the work has stuck there because of same problem, sir. Instability of slopes. I'm happy to tell you that now the ministry at much greater cost has said that further cutting the hills, we will go with tunnel technology. And we are building 2 additional tunnels to bypass and circumnavigate those unstable portions. I think, sir, in our country, tunnel technology, well, we look at big tunnels like Atal Tunnel and Chennai Nashri Tunnel and the Zedmore Tunnel. But the tunnel-based solution is going to be an integral part of trying to save these hills of ours.
So we all look forward to hearing you all and being enlightened, because sitting in the court, we have our own limitations and the exposures are limited to what is brought before us. It's a very varied panel of experts, and we look forward to getting and learning from their experiences and how they are proceeding further.
Sir, I think all the panelists have joined.
Good morning. I think if we are all set, we can start. 11:14 now. Yeah. Very good morning to all the distinguished panelists. My name is Pusha Kumar. I'm coming from. Nice.
टाइम कितना हुआ टाइम? सर नमस्कार सर, अभय सिंह सर नमस्कार. Sir, I think we can start.
Very good.
Malvika,
yes.
you can.
I'm just waiting.
You can start, Malvika.
Yes.
Yeah.
Oh,
Rajesh Beniwale sir have joined or not? Rajesh Beniwale sir.
Good morning, all the distinguished speakers.
Sir.
Namaskar.
Yes, Asutosh, want to say something?
Malvika, you can start.
A very good morning and a warm welcome to all of you. We feel fortunate to acknowledge your kind presence in the 6th session of the 3rd International Conference on Mediation. I am Dr. Malvika Upadhyay, a postdoctoral fellow at the Delhi School of Public Policy and Governance Institution of Eminence. I feel very fortunate to welcome you all to this very important session entitled Role of Mediation in Environment and Infrastructure Dispute. May I begin first by welcoming our esteemed dignitaries. I feel delighted to extend a wholehearted welcome to the chair for this session, Honorable Justice Mr. Ashwini Kumar Mishra, Judge, Allahabad High Court. So we feel extremely honored to have your kind presence in this session here with us today, and are looking forward to learning immensely from your precious words. I feel privileged to welcome the co-chair for this session, Honorable Ms. Justice Anita Sumanth, Judge, Madras High Court. Ma'am, many thanks for your gracious presence. I would also like to extend a warm welcome to our distinguished special guest for this session, Shri Amit Kumar Ghosh, IAS Additional Secretary, Ministry of Road Transport and Highway, Shri Abhay Kumar Singh, Chairman and Managing Director, Director Personnel, Additional Charge, National Hydroelectric Power Corporation, and Dr. Rajesh Beniwale, Director General, RFRF. I would also like to welcome our moderator for this session, Professor Pusha Kumar Lakshmanan, Professor, Faculty of Law, University of Delhi. I would also indeed like to extend heartiest welcome to all other dignitaries, faculty members, researchers, and dear students present in this session. Without any further delay, may we open the session with a welcome address by Professor Pusha Kumar Lakshmanan, moderator of this session and Professor, Faculty of Law, University of Delhi. Sir has been a Fulbright scholar at Harvard Law School, University of Harvard, USA.
Yes.
And has also been a research fellow at Max Planck Institute for Comparative Public Law and International Law, Heidelberg, Germany. So may I please request you to kindly deliver the welcome address. Over to you, sir.
Thank you very much, Malvika. Very good morning to all of you. Now we are in session 6 of the conference. In this session, we are going to focus on the role of mediation in environment and infrastructure disputes. Now we all know about the effectiveness of mediation in resolving disputes. There is a huge potential, in fact, in resolving the environmental and infrastructural disputes. And we have been exploring this, not only in India, in many countries, this has been successfully explored, and they are finding it very useful. In order to discuss this topic, we have a very distinguished panel of experts today with us. The chair of the session is Honorable Justice Ashwini Kumar Mishra ji, Judge, Allahabad High Court. The co-chair is Honorable Justice Anita Sumanth, Judge, Madras High Court. And our special guests are Dr. Rajesh Beniwale, Director General of Research for Resurgence Foundation, Nagpur. Shri Abhay Kumar Singh ji, Chairman and Managing Director and Director of National Hydroelectric Power Corporation. Shri Amit Kumar Ghosh, IAS, Additional Secretary, Ministry of Road, Transport and Highways. I welcome all the distinguished panelists and speakers for taking their time and to share their experience on this topic with all of us. I also welcome all the participants for the session. We are really going to discuss an important aspect because environmental disputes are huge in number. There are multiple stakeholders in this. And many times, we fight these cases in the NGT and the higher judiciary, and many years are being spent, and we struggle a lot in resolving the disputes. Mediation is a hope for all of us that, if there is any win-win situation that we can apply and we can get a quick remedy and effective remedy. And we really look forward to this session to guide us and understand how mediation will help us in resolving environmental and infrastructure disputes. As the time is the essence, I request the learned speakers to please stick to the time slot, and that will be very helpful for us to move forward with the other sessions also. Thank you very much. Over to Malvika.
Thank you so much, sir, for your very kind words. Now may I please invite our special guest, Dr. Rajesh Beniwale, Director General, RFRF. Sir has been a member of several committees constituted by Ministry of Environment, Forest and Climate Change, Ministry of New and Renewable Energy, Pollution Control Boards, UNDP, Namami Chandrabhaga, India UK DST Task Force, and others. Sir has also more than 50 publications in reputed journals, 3 Indian patents, 3 international patents, and has delivered more than 200 invited lectures. So with utmost pleasure, may I please request you to kindly take over the virtual podium and share your ideas with us on the role of mediation in environment and infrastructure disputes. Thank you.
Thank you, Malvika. Chair of the session, Honorable Ashwin Kumar Mishraji, Justice Ashwin Kumar Mishraji, Co-Chair Justice Anita Sumanth. And my fellow panelist, Pushpa Kumarji. I am being in the environment for last 25 years. I am not the student or the researcher or even the practitioner of the law. So probably I may not be able to understand how the law progresses and how the things progresses. However, I understand the environment, the impact of the environment, how does it matters, how scientifically you can analyze it, how can scientifically you can look at the remediation part of it. That's what I understand. I was fortunate to slightly have some kind of intro with how to deal with the legal framework on the environment, because I contributed to the State Expert Appraisal Committee on Infrastructure for the Environment for MOEF CC for about 7 years, 2 terms in MOEF-CC's committee, where I learned several things. I learned a lot of things to how to deal with even in the legal framework. When we talk about the environment, and when we talk about the environment particularly for the infrastructure projects, when we are looking at the infrastructure things, one of the important, there are several acts and the laws we started with 1974 Water Act, where the first time the environment has been taken into consideration. And it followed by Air Act in 1981, and then followed by the Environment Protection Act, then Municipal Solid Waste Rules. Several such things has come into the as a legal framework which were existing. To understand a kind of a mechanism for the infrastructure's environment, one has to start with the planning, and at the planning stage, there are environmental clearances being granted by the State Expert Appraisal Committee who appraises the projects, which are forwarded to the state authorities, environmental authorities, and state environmental impact authorities, and they actually deliver the environmental clearances to the projects. The process is largely governed by Environmental Impact Assessment Notification 2006, which is called shortly EI Notification 2006, and it is largely governed by that. Of course, some part of the wisdom is also with the committee to understand the environment in the total. Whenever we came across any of these projects, which were large projects for the infrastructure, previously there was only one point which was looked into consideration was particulate matter emission. And the particulate matter emission is really of the concern when the construction works goes on. A lot of dust gets emitted, and particularly when it becomes PM10 or PM2.5, means particulate matter less than 2.5 micron size, it actually behaves like a gas, and therefore it's more harmful because it will actually goes through a respiratory system. However, we have to look at it at a larger perspective of us today when we are looking at the COP26, which was held the latter part of the last year in Glasgow, and where the country has given some commitment. Every country has given some commitments for mitigating the climate change through reduction into the carbon footprint. So whenever there is a construction goes on, there is a lot of carbon dioxide being emitted. Say for example, the cement being used, which actually produces using the grid energy as of today, and a lot of other fossil fuels as well. So you have a lot of other than the particulate emission, you have a lot of CO2 emission and other gases emissions as well. So one has to have a holistic approach towards finding out what is that goes into the planning of the construction phase itself. This is what is called environmental assessment report, which is being prepared. Beyond that, the very integral part of this AI report would be the environment management plan. And the environment management plan has to meet a lot of standards which are prevailing in the country for all those pollutions which are expected to be created, all those environmental impact to be created during the construction project. So this is which is important part of it, that we need to look at what kind of emissions are there. So since the time is very less, I'm just going to put two more points and conclude my remarks. Is the planning stage, most of the projects looks very good because they do consider the environmental issues in a very beautiful fashion. What we need is a stringent monitoring mechanism during the construction as well as operation phase. And these stringent monitoring mechanisms has to include some of the automated systems, because many a times when the manual interventions are there, there is a likely possibility that we may not get the exact and the real-time data which is required, and we may have some of the data gaps to be created. So to understand that, we need to worry about the kind of monitoring mechanisms and the technologies for the monitoring as well. During the construction phase also is important, but during the planning, one more aspect has to be considered is the total life cycle approach to the project. So there are 2-3 important concepts which need to be considered. One is the complete life cycle of the project and what are the emissions being created. Second is, today's context, carbon footprint is another important aspect. And the third would be ecological damage loss, which would be either monetary terms or either in terms of the environment, where some factors such as global hectares are the parameters which are considered. This is nothing but the amount of the forest which would be required to offset this ecological damage which has been created by the project. So that is to be considered. So these calculations has to be there. And the environmental scientists, environmental researchers, environmental institutions has a big role to play to create this knowledge base for policymakers, for judiciary to look at, to create a base for actually to understand and kind of monitor this entire infrastructure thing. The last point which I want to make over here is sometimes this is my humble request, and to my understanding as an environmental scientist, I am trying to put it across you learned people. This is something which I always has been wondering. Whenever there is a dispute into certain kind of infrastructure projects, many times we, because of certain issues or certain legal aspects of it, many times it is to be removed, that structure has to be removed. And during the construction and the planning, lot of environmental management plans are created. But during the removal of that kind of structure, which is probably a disputed structure or something, no environment management plan is being prepared as of now. At least to my knowledge, I have not seen. So we must insist even for those kind of things, because the another pollutant which we create, another waste which we create by this is tons of construction and demolition waste, which is also a concern in the country as of now. So we do hear a lot of things on the plastic, we do hear a lot of things on the particulate matter, but there are few more pollutants, few more waste which are generated are the construction demolition waste as well as e-waste, which is not being so talked, but we are having the great problem at our hand. So I will conclude my remark over here. It's like emphasizing the role of environmental scientists, environmental researchers, and the environmental institutions to create the knowledge base, to build around the entire system into the 3 aspects of it: life cycle analysis, ecological damage, and the carbon footprint, which are of the concern today. Thank you very much. I'll stop here.
Thank you so much, sir, for providing a sagacious understanding on the subject. And personally, I learned a lot about the Environment Assessment Report and a lot of other relevant points that you highlighted. Taking the session further, may I request our special guest, Shri Abhay Kumar Singh, Chairman and Managing Director, Director Personnel, Additional Charge, National Hydroelectric Power Corporation, also the Chairman of Board of Directors of NHTC Limited and Loktak Downstream Hydroelectric Corporation Limited, to kindly bestow upon us his wise ideas. Thank you so much, sir.
Thank you. Honorable Justice Ashwini Misra ji, Justice Anita Sumanth ji, my co-panelists and dear participants, good morning to you all. It is indeed my pleasure to be a part of this wonderful conference and listening to such a thought-provoking deliberations. Our country has a long history of resolving issues and disputes through mediation. Mediation is deeply embedded in Indian culture and is prevalent in India from ancient times. Even in Mahabharata, there is an example of early attempt of mediation. Lord Sri Krishna strived to mediate the dispute between Pandavas and Kauravas. Mediation is the most economical and simplest option available for settlement of dispute in India. Even today, Panch or Panch Parmeshwar, comprising of elderly and the respected members of the village community, act as a neutral third parties in Panchayat who settle the dispute informally between the individuals or groups. Mediation is highly effective for achieving harmonious resolution of conflicts arising in different sectors and infrastructure sector. Is not different, and any problem can be referred to mediation. Every problem, you name it, and you can resolve. In mediation, only one is simply discussing the problem and sorting it out. Mediation is just opening again the communication that has stopped to resolve the issue in hand. Now that is what mediation is common. I belong to the hydropower sector, and we have different type of disputes. Once when we reach to site and we start the work, after this all the clearances, we're talking about the environment and the forest, etc. And when we get the approval from EIA and EMP is done with the consultation of the stakeholders. But when we landed to work site, the things start afresh by some disgruntled or anti-dam body people or some foreign agency were invoking the locals, NGOs, and it create problem. I can share one of the example of my Subhasri project in Arunachal, where all the clearances and every technical details were obtained from the various government agencies, and then only we started the work. But for more than 9.5 years, the work was just stalled for the reason that is going to harm in the downstream area. And we are working since last 45 years in the hydro sector, and we are quite competent in handling all the situations. Our design since checked by the Central Water Commission, they're expert in the field. And then only for seeking all the best practices in the world, everything is designed. The people sitting in NGOs and the member doesn't have any knowledge of the dam, their effect later on, the seismicity, everything. They go into the court and the stay order is given. And then what is happening is a huge IDC is there. I can talk about that Subhasri, the project cost was only 6,000 crores and it started in 2005. And now the cost has gone to 20,000 crores. Just imagine what the loss to the country. It is a public money only. And finally the judgment came, okay, you can start the work after 9.5 years. Just can imagine how the public money is. You can just see the difference. Ultimately, they book to the public only. The tariff at that time would have come only to less than 2 rupees. Now the tariff for the power is coming around 5.5 rupees. So see the difference. Balance 3 rupees had to be given by the public only. These all things happening. Then when you use the contractor for this work, they go for the arbitration claims. And now one thing is there. Even in the Arbitration Act, the things have to be resolved in some limited time. Say 6 months, 1 year, or some extension for 1.5 years, but it's taking 10 years of time because the contractors has now make a habit to delay the thing. The people get retired, they're unable to put the facts. Suppose I'm sitting on the chair, somebody come after 2 years, 1 year, then he doesn't know how the past. We go through the papers only. They are the expert. They are keeping their not engineer side. They are keeping the advocates there. From the day one, how to raise some claims. These practices have to be seen how it can be discouraged. And the arbitrator, they are not expert in the technical matters most of the time. Most of the time, the retired judges, they know the legality, but they're not knowing, suppose they have claimed 100 crore, so how this 100 crore has come. So there are no basis of the detail of the 100 crore. But legally, if they say, okay, this is claim is admissible under so and so clauses. So simply they award, number one. Number two, they award with interest. Interest is 16%, 14%. We go in the market, we are getting 6% of interest. And the delay, suppose the cases are to be finalized in 6 months' time, 1.5 year time. It is finalized of 10 years. 10 years, they are putting the interest part. So this all things going against the PSUs particularly, because it is public money. We want to settle the things, but settle the things in some proper way. But things are not happening. So mediation is definitely going to help us. Even the ministry are now decided to put some people at site itself to see what the both sides are doing. And we have changed a lot considering the past experiences, how to deal with these people, and keep on writing on a monthly basis what the resources are available, what the challenges are there, and why the progress has not achieved. So now the documentation is now done in a better way. What you used to do earlier, not only in my sector, is everywhere now. And one judgment comes from the Niti Aayog, not a judgment, is a policy comes from the Niti Aayog. All the dispute and their award of arbitration award is there. You can release 75%. Since then, it is a flood of arbitration only. Because most of these infra companies don't do NPA. So they want some money somehow so that their NPA can be avoided. So now they have started doing the arbitration. With the arbitration, they're getting some amount and you have to pay 75%. Sometimes what is happening, even they are unable to provide the bank guarantees. Then they are approaching to the court, see what the people have done against us. They have killed our companies and now it doesn't have the bank guarantee to release the money to our account so that we can give it to bank. So at least public money through the PSUs is going to this contractors, infra companies for which we are not responsible. So this all are happening. How this we can do and put something. We are also planning to write some letter so that this can be avoided. And if genuine claims are there, definitely want to do it also. And we're doing also. But sometimes what is happening, suppose you decide something, even if it is 100% correct, then some party just go to the various agencies, see the people have given favor to the contractors. So it is very correct, very in a systematic manner. So nobody is daring to decide anything. Suppose you decide anything, then some CBI will come after you. So why to decide you getting surgery, enjoying your post? So let us not do anything. And that because there are no anything there who can defend the people who are taking decision. So everybody wants that third party should do something. Then we are safe. So just becomes safety for everyone. Nobody taking decision. There are genuine things also. So these all things needed to be put somewhere so that we will definitely do the things. What is genuine for the delay or any other issues. In the case of our sector, handing over the land, then some environment issue, then sometimes the hydrological issue, then some geological challenges. But everything is given in the contract. Provisions are there. Then what the arbitrators are giving the judgment. This is the best practices. When we have the very specific clauses in the contract, then why you are talking about the best practices? There is no speaking order also. Okay, why they have arrived and awarding this contract amount this much of the dispute? So just the best practices, one line the best practices, no speaking order, and then the amount come final with the interest rate, either with the deposit in the court or you fight in the court. It may go years and years. In case of an SBC, we have around more than 9,000 crore of contingent liability. In most of the cases, the awarded are the best practices. So these things need to be curbed with some provision in the our act. At the same time, mediation is definitely something is going to help us if the things are resolved at the very initial stages. So I think I have to say from my side, definitely our team is working in it because now we are putting our law firms. where law firms right from the day one, contractor is not writing anything. We are keep on writing, okay, your resources is not there. You doesn't require manpower. You are not providing any input to the site for the expeditious progress of the work. They're just keeping quiet. After 5 months, 6 months time, they come with a very nice letter, replying all the replies for last 6 months. That's becoming the regard because they are more expert in the legal matter. We are more expert in the technical matter. So it doesn't have any knowledge of the legal thing. So now we have started putting the law firm from the day one and asking them to visit the site to see the condition. That is the reason. So now they are afraid with us. And since last 1 month, 1 year, we are not getting the arbitration claim. They are just waiting. Okay, let the system can. If destroyed something in the system, in our system, so then they further come with arbitration claims. So these are all happening to take the public money from the PSO by the arbitrators. And arbitrators doesn't want to name. They are so experienced in the retired chief justices of India. If they can write as arbitrator, it is best practices. They should go as per the contract provision. What is the contractor risk? What is the contractor obligation? What is the employer risk? What is the employer obligation? So these things are not there in the arbitration award. And the money part, suppose they claim 100 crore, how they have arrived at 100 crore. That also need to be examined. Once they decided to award something, okay, technically, legally we award, this contract is okay, and the amount to be given to the contractor as a compensation. But how to arrive the amount? Because initially, we don't at all consider about any amount. We simply consider legally is not possible as per the contract provisions. So these are things to be addressed at some forum. And today the matter of mediation, we are not much experienced on the mediation, but definitely are looking forward if something can be done at the early stage only, and it's definitely going to help both the parties, if the both parties are interested. With all this, my once again special thanks to Mr. Asutosh Mishra, is a very good friend of mine, and he asked me to join this discussion, and really great to see Justice Ashwini Mishra ji. Luckily, we belong to the same area. His house and parental house, my parental house is only less than a kilometer distance in district Deoria. Thank you, Mishra ji. Thank you, Asutosh ji. Namaskar.
Thank you so much, sir, for your insightful talk and for bringing on surface many pragmatic points of this issue. Well, now continuing with our intellectual exploration, may I take the pleasure of inviting our third special guest for this session, Shri Amit Kumar Ghosh, IAS, Additional Secretary, Ministry of Road, Transport and Highways, to kindly enlighten us with his learned ideas on the role of mediation in environment and infrastructure dispute. Please, sir.
Thank you so much. Honorable Justice Ashwini Kumar Mishra ji, the chair of today's session. Honorable Justice Anita Sumanth ji, the co-chair. Professor Pusha, the learned moderator. My eminent co-panelists. Given the paucity of time, I have decided to deviate from my prepared preparation, and I'm going to come straight to the heart of the matter. There was a study done recently in the year 2020 by Niti Aayog. They have a division called the Development Monitoring and Evaluation Office, DMEO of Niti Aayog, where they examined the arbitration and alternate dispute resolution processes which are followed by NHAI, which is, as you know, a subordinate or an autonomous organization under the Ministry of Road Transport and Highways. Now, I will just quote 3-4 observations and then immediately go to the role of mediation. The report says that NHAI follows 2 broad types of ADRs. That is, number 1, arbitration, and number 2, conciliation. And the Arbitration and Conciliation Act of 1996, as amended as the Act of 2015, has brought into effect more focus on institutional arbitration. So this is the basis of dispute resolution and mediation insofar as my ministry and the road sector is concerned. Now, the study notes that NHAI has been relying on both formal and informal methods of ADR. So, while it classifies proper arbitration processes as the formal process, formal means of arbitration or dispute resolution, it also recognizes that NHAI has been striving to institute other mechanisms. One of those mechanisms was the much maligned, I can tell you, the much maligned 3 CGM committee. The 3 chief general managers of NHAI were supposed to examine the claim of an arbitrator and of a party, the aggrieved party, and then give its findings. The results were abysmal, and that relates to what my preceding speaker said about the fear of taking a decision. So the fear of taking a decision pervades the system. Now, I would like to very quickly come to what we have done in the last 2 years. I've been here in this ministry for the last 4.5 years. So Bharatmala, I had the honor of and privilege of piloting through the cabinet, and it is the largest program, as you can see. So what we have done, sir, here, I would like to say that in 2019, on the 18th of December, we took a policy decision and issued a policy circular, which is titled Conciliation and Settlement Mechanism for Contractual Disputes in Contract Agreements with the Contractors, Concessionaires, Consultants in respect of Ministries' projects. Further, panel of independent experts and constitution of conciliation committee. Today we have 3 conciliation committees, and each committee has 3 members. The general structure of a conciliation committee is that of a retired judge from the High Court or Supreme Court, a retired Director General of the Ministry who has adequate technical knowledge, and a retired Secretary Government of India who has experience in handling disputes of contractual matters across sectors. So this policy has provided a detailed mechanism for SOP for referring the dispute matter to a CCIE for conciliation, providing for broad terms and conditions and terms of reference for conciliation committees of independent experts, obtaining, which is done by the office of the chairman of the NHAI proper, obtaining consent of the concessionaire, contractor, consulting party for giving formal written consent for conciliation, and then providing for procedure, methodology evolved by a panel for conciliation through conciliation committee. So what I'm saying is that these are developing areas of mediation, dispute settlement, and as observed by Mr. Abhay Kumar Singh, he was speaking on behalf of the hydroelectric power sector. The mechanisms may be developing there also. I'm happy to share with you that NHAI, the ADR in NHAI is recognized as one of the most well structured. Though the fact is that also here, there's a very interesting data that I would like to mention at this stage. The study notes, the DMEO study, that a trend analysis shows, I'm quoting, a trend analysis shows that claims against NHAI have gone up by 7 times within just 2 years from 2016 to 2018. That is why in 2019, we had to issue a policy circular for conciliation. So I think that, arbitration alone is not able to resolve all the matters. Now, coming to very quickly to the Niti Aayog circular on paying 75%, I would like to disagree very marginally with Abhay Kumar Singh. I think that, many infra companies in India are very stressed, and we find them approaching the NCLT, as a matter of routine. while it should be an exception. So it is the duty of the authority giving the contract to make sure that if there is a liquidity problem, the authority which has given the contract should step out and help the company rather than allowing the company to go bankrupt or NPA and then go to NCA. But that was just my personal observation. Here I would like to come back to the other, apart from conciliation, arbitration proper. Now, in arbitration, there are a very large number of cases, and the media also keep writing about the load of the claims through arbitration on NHAI. It is a fact, and I would like to just tell you that the study has, the Niti Aayog study referred to 554 arbitral awards. 95% of the claims were made by concessionaires amounting to 28,524 crores, and remaining 26 were initiated by NHAI with claims of about 98 crores. It is true what Abhay ji said, that there are companies which believe in very effective arbitration rather than effective implementation of the project. And there are, it's a joke that there are a few companies which the day they get a contract, they also open a parallel file for filing claims against NHAI. So given this kind of, aberrations also, I treat these as aberrations. I think that the role of mediation and the role of arbitration is very, very important. Role of conciliation as well as arbitration as forms of mediation is very, very important. Here I would like to say something. For some reason, in 2012, the dispute resolution boards, which were part of the EPC contract document, EPC agreement, were done away with. I'm very happy to share with all of you that last year I moved a proposal, and there the interministerial committee consisting of representatives from Ministry of Finance, Niti Aayog, Law, everybody had agreed, and we have reintroduced dispute resolution boards at every state so that the dispute should not await resolution at the end of the completion of the work stage. It should get resolved concomitantly as the work is progressing. My time being limited, I had some more information to share. The only thing on the environmental side I would like to say is that following the orders of Honorable Supreme Court, I just want to give one example. The Ministry of Environment and Forest had constituted a committee under the chair of the chairman of the Bombay Natural History Society. And I was deputed from my ministry to present the case. And I had NHAI officers to assist me. And we, the question that was raised before Honorable Court arising out of the decision taken by by one High Court was that when we are broadening an existing highway, then we naturally, because of the load of traffic which is growing forever, we do require more land to be acquired. And once that land is acquired, what are the environmental considerations? What are the procedures to be followed? So I just want to emphasize the role of Honorable Supreme Court in giving the directions to the Ministry of Environment Forest, and what they did, they brought in an honest player, the Bombay Natural History Society chairman, and a panel of experts from CRRI and other environmental organizations. And we presented our case. And I'm happy to tell you that we have been able to lead our case successfully. So these are also informal means of mediation. I would like to once again thank Dr. Ashutosh Mishra and the University of Delhi for giving me their precious, their permission. And I was able to come here and appear before so many learned people and present one aspect of dispute resolution through mediation. I hope that I will learn from all the other speakers and be able to further add to the policy requirements at the government level. Thank you very much.
Thank you very much, sir.
Thank you for enriching our knowledge on the subject, sir. After these vital words of information, may I now take the privilege of inviting our co-chair for this session, Honorable Justice Ms. Anita Sumanth, Judge, Madras High Court, and an expert on direct and indirect taxes and corporate laws. Ma'am, may I please invite you to the virtual podium and request you to provide to us the honor of learning more on the topic, role of mediation in environment and infrastructure dispute from you. Over to you.
Thank you very much. At the outset, let me thank Dr. Mishra for this invitation. It's a pleasure and privilege to be participating in this discussion. And the presentations made by the speakers, the erudite speakers before me, have been extremely illuminating and interesting. They have encapsulated very, very real concerns that face the environmental and infrastructural projects that we undertake in the country here. Now, the role of mediation in such projects simply cannot be understated. And while one may not be able to prioritize one branch of disputes over another branch of disputes for the purposes of application of alternate dispute resolution mechanisms or ADR mechanisms, there are some areas that, in my considered view, would have to take an edge over the others. And two such would be environmental and infrastructural projects, for the reason, simple reason, is that environment is a public concern. The preservation of the environment is a public concern, and all of us as stakeholders in society have a role to play and are interested in settlement of these disputes. Then again, infrastructural projects are touch upon lives of society, they impact the economic life and the fabric of society itself, and bearing in mind the large public interest that they have, the fact that there are multiple stakeholders in both kinds of projects, I would think that these two sectors would have an edge when it comes to making a full-on attempt to application of ADR systems. Now, as a rule, they say that mediation is for those who would finish rather than fight. Thus, if one wants to feud, if one wants to litigate endlessly, an ADR mechanism, much less mediation, is simply not for such a sector. I think the presentations made by the speakers before us would stand as ample testimony to the results, the success that ADR mechanisms have had as far as environment is concerned, as far as infrastructural disputes are concerned. And one very important aspect here is, while we look at the impact of ADR mechanisms for all the direct stakeholders in both environment and infrastructure, we have an indirect stakeholder, which is the environment itself, the preservation of the environment, the preservation of natural resources, the preservation of wildlife, flora, fauna, etc., for which we have to provide a voice in all these circumstances. I had recently occasion to participate in a conference involving various aspects of civil litigation, and one of those panels touched upon the area of complexification of litigation. And when one looks at complexification, we are looking essentially as litigation as we understand it today, with all its complexities, with all its rigor, with all the baggage that it brings along with it. And as rightly illustrated earlier, these disputes involving the environment and infrastructure could do well with the taking away of all the complexification. And by this, I would say that the speakers mentioned the dispute resolution boards that we have at various stages of the project. This would bring to bear on the expedited nature of the project itself, bearing in mind the fact that these are all projects that touch on public necessities, on social needs and requirements. I dealt with a matter involving two Navratna companies recently, two PSUs. And in the course of that, I found that this was a revelation to me because I learned this in the course of that hearing, that there was an office memorandum that provided for a template for dealing with the matters alternatively, without resorting to traditional methods of litigation. And even in that, I found that there was a bilateral approach. This template said that where the dispute was qua the PSU and a private party, then it would be referred to arbitration. The provisions of the 1996 Act would apply, and all the consequences would follow. When it comes to a dispute qua the PSU and a PSU, then it referred it to a dispute resolution board. And that dispute resolution board was to comprise of the secretaries of the two departments, under which the two PSUs would function. And then the third mediator or arbitrator or the resolution personnel would be the principal secretary. Now, if you look at the composition of the two dispute resolution boards itself, in the first case, where the PSU was litigating with a third party, those disputes would be referred to, as is always the case, a personnel drawn from the PSU itself. And then it would take the normal course of litigation. Whereas in a case involving two PSUs, I found the approach was a little different and perhaps more aligned to an expeditious and a realistic and a holistic method of dispute resolution. Some real concerns were expressed by the speakers when it came to the fear factor. They spoke of the fear factor. I would add to that by saying there is also a danger factor, because when you're looking at mediation per se, you're looking at giving them a wide discretion. You're looking at giving the authorities wide discretion to deal with disputes often involving high stakes, significant stakes. This is us now when we talk of environment and infrastructure, in many a project, you have a spillover, because an infrastructure would very often touch upon the environmental aspects as well. Therefore, you're looking at giving them wide discretion at so many levels to solve the dispute. How do you make them accountable? How do you make them accountable to ensure that with such power comes such great responsibility as well? So this is a very important aspect that I wish we all apply our mind to. And while I would endorse the view 200% that mediation must be resorted to as a method of dispute resolution, one must formalize the mechanism. One must arm the officials. One must equip them with the power, the responsibility, the manner in which they go about settlement. Let me give you an example. Just before we started the conference, we were talking about the ravages of nature in two instances. One was in Kashi, and then I mentioned Tirupati as well. Now, if you take two hill stations in the state of Tamil Nadu, from where I come, you have Kodaikanal. And both in Uttakamand and Kodaikanal, the place is rife with avalanches. And these are because of indiscriminate slicing of the hillsides to make roads, indiscriminate construction, and various other ecological damage that is being done on a day-on-day basis. And one thing that we found is one of the problems, just one of the problems that we identified as a reason was the kind of trees that grew there. The trees that are native are said to be the sholas, whereas we have trees that are today, you find in Kodaikanal, you will all know that eucalyptus oil is very, very famous from there. And that is because eucalyptus grows there, which is in fact a species which is not native to Kodaikanal. Now, the root system of these two different kinds of trees are said to have an impact on both the water table as well as in how they hold the soil to give it stability to hold, particularly when you're talking about a hillside. Now, I'm no expert on environment. I would only lay claim as a very, very interested citizen and a very, very interested stakeholder in such matters. And as a member of a judiciary, my responsibilities are different, of course. But I would say that when you mediate on such disputes, it becomes extremely important to take into account local opinion, because it's people on the field there who are experts. Mr. Beniwale spoke beautifully about the importance of assessment and of the importance of planning. I cannot underscore that enough. The previous speakers touched upon how very important these aspects were. And he also said, I have 20 or 25 years of experience, and experience in the field of environment and not in law. But when it comes to resolution of such disputes, we need people like these to sit at the table and help manage and resolve those disputes. Without such inputs, the act of resolution of the dispute would remain a farce. Therefore, inputs from experts, inputs from planners, inputs from officials, inputs from locals, in many cases, because infrastructure projects tend to displace locals, they tend to make changes and alterations to their lifestyle that must be taken into account. You know, day on day, I sit on the writ portfolio where when a highway is laid, both Mr. Singh and Mr. Ghosh would know that when a highway is laid, you're talking about electrification. You're dealing with the rights of farmers who have their farms along the highways. How do you balance it? It's a balancing act. So while deciding such policy, not only at the stage of designing of the policy, conceptualizing of the policy, you have to take note of the requirements at the stage of execution and at the stage of dispute resolution as well. I was just doing some research and I found that Taiwan and many other jurisdictions had provided for legislation to equip and arm government officials to address these issues in a proper manner, so that they take into account the interest of all stakeholders and they address it in as judicious a manner as possible. There are judges from Madras who have spoken in the previous sessions. Justice Chakravarti has spoken yesterday. Justice Govindraj has also spoken. So they would have spoken to you about the Tamil Nadu Mediation Center. I'm not going to trouble you with that. I'm not going to touch upon the statistics of disposals, etc. We are here to discuss larger questions on policy and how these issues can be addressed. So I will not touch on that. My only request would be that most environment concerns are driven by passion. And we should take a cue from that passion. As policymakers, as people who enforce the policy, as judges, we should also take a cue from that passion and ensure that we are driven by the same passion to ensure that those policies are carried forward in the best way possible. As I know we are racing against time and I have perhaps exceeded my brief as well. The last session that was chaired by Justice Pratibha Singh, a very, very interesting session indeed. One of the speakers there spoke about the Ramayana. And he said today being Ram Navami, he drew a connection between the present conference and the Ramayana. I would draw a greater connection between the Ramayana and the subjects that we are speaking about in this panel, which are infrastructure and environment. You look at the Ramayana. Had the process of mediation been followed by Rama and Ravana in the Ramayana, the whole of Lanka would not have been burnt down. The infrastructure of Lanka would have been saved. So many ecological and environmental concerns would have been protected and preserved. So, well, that was just an aside. The meaning and the depth, the purpose of the Ramayana is entirely different. I concede to that. But on a lighter note, since it was mentioned in the earlier session, I thought that I would say that the relevance of this session, particularly today, is very, very great. Thank you very much for this chance to meet all of you, to listen to your views and the deliberations. Thank you once again to Mr. Mishra for this invitation, and have a good day.
Thank you very much, ma'am. Wonderful. Yeah. Thanks a lot. Yes.
Many thanks for your extremely interesting, candid, and useful talk, ma'am. Now in this journey of learning about the role of mediation in environment and infrastructure dispute, may I take this noble opportunity of inviting our esteemed chair, Honorable Justice Mr. Ashwini Kumar Mishra, Judge, Allahabad High Court, serve as a renowned senior advocate and was engaged in the arguing counsel for many statutory bodies like Noida, Ghaziabad Development Authority, Allahabad Development Authority, IFCO, IOC, UP, Power Corporation, and others. So with immense respect and delight, may I kindly request you to please grace the virtual podium and enrich our knowledge on this very important topic. Over to you, sir.
Very good afternoon to all of you. And it's really been a pleasure and privilege to hear all my co-panelists and my esteemed sister, Justice Anita Sumanth, with her exposition on the field. I am also delighted to be in the company of Mr. Abhay Singh, as he just pointed out that we come from nearby areas. And Mr. Amit Kumar Ghosh is also connected to Allahabad in certain ways, as I've come to know. So let's begin. The conference is on mediation, and it has many facets in what, in different fields, how it can resolve differences. The problems, as Mr. Abhay Singh highlighted, is in one particular sector, but it stretches in all fields. We want quick resolution of disputes. We do not want the costs to go up. We also want the competing interests to be addressed and to ensure that we resolve disputes in a humane manner. The persons who are coming to any forum are in trouble, and it is the responsibility of the state to ensure that we resolve their differences. We do it in such a manner that it is less time consuming, it is not expensive, and it also gives certain autonomy to the person who is actually in trouble. I'm a firm believer of mediation, because what it actually does is that it is a peace, the mediator we call, but it is actually a peace giver. What he tries to do is that he tries to understand the complexity of the problem. He understands the different views, as Mr. Beniwale said, that we have to have planning. We have to have so many environmental clearances. The other aspect is, as is being highlighted by Mr. Abhay Singh, is that the contractors, the agencies which actually work for these infrastructural projects, they have their own concerns. I think he has some trouble and difficulties handling those areas, but that is an obvious outcome once we have the process not structured in such a manner that we are able to resolve the issues in a quick time. And in fact, that is the occasion that this gives us the reason for this particular conference, and to explore as to whether mediation can be one of the ways. Mediation, as we understand, it's a third party sitting with the two rival parties, and the two parties coming up with their concerns. It firstly meet one side, then it meets them jointly. And the idea is to come out with something which is common between the two, and then to persuade the other party to see reason. Many times there are unfounded fears. As in the case of environmental concerns, what we understand is that whenever it is actually nature which the human intervention is going to change it in a desirable manner as it understands. Now, the persons who are there living, those who have to be relocated to other areas, they may have their emotions attached, their economies, their life, their very existence is attached to those areas. And therefore, they are not convinced of the merits of the concept. You may have the environmental clearances, but those persons are not satisfied. Just imagine, I mean, I would not say that those concerns are less important. In fact, we are living in our houses very comfortable, and then we can say, all right, come up with such and such project. But somebody just realized, somebody in a state like Madhya Pradesh or other states where there are forest people are living their entire life, their temples, their own traditions, everything getting uprooted. So there are genuine concerns. Now, even if you are coming forward, maybe the role of NGOs, I would not like to comment on that. For every institution, there are positives, there are negatives. So I'm not going to generalize or opine on that. But what is being highlighted actually is the concern of those people. Those people may be correctly informed, maybe incorrectly informed. So how I see or understand is that mediation can be one way in which you allow both sides to see their viewpoints. It is one concern, two competing interests getting properly being interacted or being placed on a table with an expert person sitting and guiding. So this is a way which has tremendous potential. And I do feel that in matters of environment where time is the essence, where costs are huge, implications for national interests, for national economy are huge, we do need to have some sort of a setup where we can effectively and very conveniently and in a time-bound manner resolve. Now, I would like to say some more things, particularly the desirability part is one, the effectiveness of mediation, nobody can doubt. But what is the position? Once we actually come to mediation, there are no, as such, adjudications which have come to my notice, maybe that there are, of which I am not aware. But then I was just going through, because the existing setup of mediation is to a great extent being guided by the judgment of the Supreme Court in the case of AFCON's infrastructure private limited. And there the Supreme Court lays down as to what are the subjects in which mediation would be permissible and what are the subjects where the mediation would not be permissible. And paragraph 27, if I was just yesterday referring to it, since I was to get this opportunity to interact with all of you. And there I find that representative suits under Order 1 Rule 8, which involve public interest or the interests of numerous persons who are not parties before the court, is an aspect which is completely excluded from the applicability of ADR process. Then I also checked up, because this judgment was, it's one of the best authorities and treatise on the field by Honorable Justice Ravindran. I also checked up because we are in the process of getting a new legislation on mediation. So I also checked up as to what is the position in that regard. And there also I found that Section 7 lays down the disputes or matters not fit for mediation. And there, those issues or areas which are not fit for mediation have been referred to in the first schedule. The first schedule, item 8, it says any proceeding in relation to any subject matter falling within any enactment over which the tribunal constituted under National Greens Tribunal Act has jurisdiction. So what we are actually proposing, even in future with the new mediation, which is a bill which is yet to be made and converted into a law. But the thought process which is there, I think as of now, in matters of infrastructural or environmental concerns where stakes are very high, there are multi-parties, there are legislations operating, and it is not just two parties interacting or fighting or the differences being limited to individuals. Therefore, the statute or the judgment so far, it has not recognized mediation as one of the means for resolution of such disputes. This is where we stand as on date. But I would say that from what has been experienced in 2005, all offenses were thought to be ousted out of the purview of mediation. But I was going through another judgment of the Supreme Court where the Lordships have made an observation that in the matter of Negotiable Instruments Act, all disputes pending before the High Court should be taken to mediation. So the experience which over the last 10, 12 years we have gives us very encouraging, as one of the speakers, esteemed Justice Singh from the Delhi High Court, she said that during the this COVID period, the success rate was almost 45%. And in Allahabad and in other places also, the mediation centers are seeing a good number of matters, in fact, all matrimonial matters, where as a matter of routine settlement. So there is a lot of potential. What I think we can think about is that instead the process may have to be tweaked to a certain extent. What we can do is that we can think of a multi-body mediation process being resorted to in these matters. The representative of the companies which are coming up, the department, the public sector undertaking, and also the common man who is likely to be affected. And maybe if they all sit together for mediation and are able to understand the complexities of the problem, the concerns which each other share, I'm quite sure that major differences which at least emanate from an unawareness or lack of awareness about the ground realities, that would get sorted out. And that would then pave the way for an appropriate adjudication. And even if the mediation doesn't succeed in those fields, yet there is a better understanding of the position by the two sides. So in my understanding, and I would use this platform to make this humble appeal, that we have to give a real serious thought if we want infrastructure and environmental concerns, which are of great importance for the country. And equally important is the dispute resolution mechanism to be strengthened. We must give a very serious thought and try and find out in what manner we can use the art of mediation to see that actually the peace giver role is spread in those areas also. I have already exceeded my time limit, and therefore I would just like, although it's always a matter of pleasure and discussing the views, and we are here all as students of law, just sharing our own understanding. I again thank the organizers of this conference, the Delhi Campus Law Center, in which I have had the good fortune of studying law, and also Professor Mishra and all my co-panelists, my sister, esteemed sister Anita. A very, very good afternoon and very good wishes for the Ramnavami, and that's how I do. Thank you.
Thank you very much, sir. Thank you.
Thanks a lot, sir, for your very meaningful and thought-invoking words. I'm sure everyone has gained a lot from it. I feel extremely privileged to thank our learned speakers for their extremely insightful and informative talks. I'm sure this wonderful session has contributed in enhancing the knowledge of each one present in here on this very relevant subject. For the same, I would like to offer heartiest thanks to all our respected dignitaries. Before we proceed further, I would like to inform you all that the link for the feedback form will appear in the chat box. Kindly fill it for your certificate. Now may I please invite Professor Kumar Lakshmanan, Professor, Faculty of Law, University of Delhi, to please present the concluding remarks and vote of thanks. Over to you, sir.
Thank you very much. Such a feast to listen to all the distinguished speakers. We are already, late, so I will just, give crisp, takeaways from this session, and thank all our, learned speakers. In fact, all the speakers have brought the multiple concerns that we have in resolving environmental disputes, because environmental disputes as well as the infrastructural disputes have, different concerns. They have special characters, in fact. Normally, when we deal with mediation, you have two parties having disputes and you have to solve that. But here, it is different. You have multiple stakeholders competing against, different, interests. Then in that case, it is not just resolving a dispute. It is, in fact, resolving a matter that will, have a long-term, impact in the life of the people, in the life of the journey of the country itself. So that is the nature of the environmental and the infrastructural disputes here. So in that context, how we are going to apply the mediation was the question. And very beautifully, they have explained with the help of the experiences that they have encountered, and also how the law can play an active role. And they have, by and large, all the speakers, have expressed the real potential of mediation. So that is a very welcoming step. And this also brings another aspect that environmental and infrastructural disputes. They also bring techno-legal aspects. So the kind of expertise that one has to mediate in such disputes is really different here. So one has to understand the environmental conservation issues, the livelihood issues, then the technical aspects involved, the science aspects involved in the issues. That also we need to look at it. So we need to think broadly for all those issues. Take quickly, from the speakers. In fact, I am very thankful to all the speakers. First, coming to Shri Rajesh Beniwale ji. He has brought his 25 years of experience to the discussion. And as a scientist, environment scientist, that he has, brought the importance of, looking into the life cycle pattern and the carbon footprint and the ecological damage and the conservation needs, while, looking into the dispute resolution. He has given the example of EAA for this purpose, and how the data plays a major role, how the different consultants and other stakeholders, decision makers play a major role here. And when Shri Abhay Kumar Singh ji spoke, he was in fact giving his real-time examples while dealing with hydroelectric power plants. He gave example of Shri project. And he explained how the difficulties, because how the public money is, getting, wasted, or, how the long delay affects the whole of the developmental projects. So there we need to think about how to balance the environment and development. So how one has to understand the infrastructure is important. At the same time, we need to look at the social and the environmental components. When Shri Amit Kumar Ghosh, spoke about how the highways projects look at this, and he quoted the report from Niti Aayog and how NHAI is very proactively contributing in resolving disputes with the application of arbitration and conciliation. And for the lack of time, I'm not explaining much. And he has, also, demonstrated how in 2012, they have, created the dispute resolution boards. And the last year, in every state, they have come out with the dispute resolution boards, and they have kickstarted the mediation as one of the resolution process. And when Honorable Justice Anita Sumanth spoke, beautifully, Madam has stated, because this is the concern we all think about. Environment is the public concern. It is not the dispute between the private parties. It's a public concern. And also, Madam has, very rightly stated that most of the environmental disputes, are driven by passion, emotions. And because, they are fearing, their life is going to be taken away. Their possibilities of future are going to be taken away. So how, when we mediate, when we apply our yardsticks to solve the problems in a balanced way, how we have to, look at all these aspects. And, Honorable Justice has also given an example of how the Navratna companies, two Navratna companies, have the two different approaches in dealing with such disputes. And, Madam has insisted on the, taking and involving the local inputs while deciding the cases. So because, normally, we look at the experts and the data and the decision makers and the data, reports for, such, resolving disputes. But here, because it is a public concern, the public interest is involved much, we need to involve the input from the local people. And beautifully, Honorable Justice has also brought that how in Ramayana, if mediation would have been applied, how we would have, approached the solving of the problem in a different way, and the protected environment and kind of a win-win situation would have happened. But that's a different context. But as an example, Honorable Justice has presented nice. Thank you very much for that. And Honorable Justice Ashwini Kumar Mishra sir, when deliberated, he has brought very important aspects, the mindset of the present day towards mediation in resolving the environmental disputes and the infrastructure disputes. That's a very key point that I think we all should, as legal scholars, we should think about. When we all plead for application of mediation, but we are not, making it ready, in the policy and the legal frameworks. That's the way. And Honorable Justice has given two examples. One is, Honorable Justice Ravindran's judgment where it is not applying or providing the scope for the environmental mediation. Secondly, the present mediation bill where Section 7 tries to exclude the disputes relating to environment aspects. So I think we need to think very clearly on this because whatever is coming out in the bill now, if it is not mended, and then the scope for the mediation will be diminished later on. So we need to give more thought on this. So with this, takeaways, there are many. I have only highlighted the important points. So if I have left out anything, kindly excuse. We will go ahead with the next sessions. And thank you very much, very profusely. I thank all the honorable judges and the respected speakers for providing your valuable time and inputs for the success of this program. Thanks a lot. We'll be in touch for learning more. Thank you.
Thank you very much.
Malvika, please take it forward. We can wrap it up.
Yeah, I think we'll be closing the session, sir. Thank you so much for participating, sir. And thank you so much, speakers and everybody, all the dignitaries, for making this session a great success. I once again thank you all with folded hands and looking forward to hear you once again. Thank you so much. Have a wonderful Sunday. Goodbye. Take care.
Thank you very much.